Justice Rishikesh Roy begins a judgment of Enforcement Directorate, Government of India versus Kapil Wadhawan by quoting the lines from John Locke's work, New Treaties of Government, where he stressed on personal liberty and stated that where there is no law, there is no freedom. In the present case, we discuss the rights of such accused whose right to default bail hangs in the balance of a difference of a single day or even less. First of all, what is a default bail? Default bail is also known as statutory bail. This is a right to bail that accrues when the police fail to complete the investigation within a specified period in respect of a person in judicial custody. Moving on to the facts of the case, the respondents were arrested on 14 May 2020 for alleged commission of offence under Section 3 of the Prevention of Money Laundering Act 2002 and were remanded on the same date. The remand period expired on 12 July 2020, which is Sunday, and on the next day, the default bail applications were presented before the court. The special judge, however, denied default bail to the respondents, taking the view that the 60th period would start from 15 May 2020, thereby excluding the date of remand. However, the High Court felt that excluding the date of remand was erroneous and held that filing of the charge sheet by the Enforcement Directorate on 13 July 2020, being the 61st day, would entitle the respondents to default bail. This decision of the High Court was stayed by the court on 3rd September 2020. Now, the issue here is whether the date of remand is to be included or excluded for considering a claim for default bail when computing the 60 or 90-day period as contemplated in Proviso A of Section 167, subsection 2 of CRPC. Section 167 discusses the procedure when the investigation cannot be completed in 24 hours. Here, in this case, the prosecution is of the opinion that the date of the remand period is to be excluded while computing the stipulated 60 or 90-day period for the right of default bail to the accused. They placed reliance on the case of State of Madhya Pradesh versus Rustam and others, which was later followed in Ravi Prakash Singh versus State of Bihar, and M. Ravindran versus Intelligence Officer, Director of Revenue Intelligence. Mr. S.V. Raju, the ASG appearing on behalf of the Enforcement Directorate, argued that one of the days on either side of the remand period has to be excluded, and in the present case, either the date of the remand or the 60th day must be excluded for computing the eligibility for default bail. He also placed reliance on the case of N. Suraya Reddy versus State of Orissa and argued that even if the period of 60 days expired on 12 July 2020, that being a Sunday, the provisions of Section 10 of General Clauses Act would come into play and the period will stand extended to Monday. On the other hand, the senior counsels for the respondents argued that the exclusion of the first day is illogical. They relied on the case of Chaganti Satyanarayan versus State of Andhra Pradesh, CBI versus Anupam J. Kulkarni, State versus Mohammad Ashraf Bhatt, and State of Maharashtra versus Bharati Chandmal Verma. Referring to these cases, they contended that the first day of the remand must be included for computing the remand period. Moving on to the discussion of the Supreme Court, the judge of the Bombay High Court cited with approval the judgment in Deepak Satyavan Kudalkar versus State of Maharashtra, where, as per Section 57 of CRPC, a person arrested cannot be detained for more than 24 hours. The time necessary for the journey from the place of arrest to the magistrate court can, however, be excluded. The further detention beyond 24 hours is subject to authorization by the magistrate. The power of the magistrate to authorize detention of the accused either in the police custody or under magisterial custody is circumscribed by the period specified in Section 167 of CRPC. If the magistrate is satisfied that continuing the custody exceeding 15 days is warranted, he may authorize such detention. But in any case, the authorized detention cannot exceed a period of 90 days or 60 days as the case may be. On expiry of the stipulated period, if the prosecution fails to file the charge sheet or the final report, the accused person has an indefeasible right to be released on default bail. In the case of Rustam, invoking Section 9 and 10 of General Clauses Act cannot be a binding judicial precedent as it is rendered per incuriam. And also Section 167 cannot be fitted into a period of limitation from and to, since there is no limitation for completion of investigation and filing of the charge sheet. And also excluding the date of a remand order would also result in a break in the continuity of the custody of the accused, which begins from his arrest and continues till the stipulated 60 or 90-day period. In Bikramjit Singh versus State of Punjab, it was observed that the right to secure default bail is a part of the procedure established by law under Article 21 of the Constitution. Therefore, the right therein is raised to the status of a fundamental right. Therefore, to claim default bail, the accused does not have to make any substantive grounds for securing bail nor file a detailed bail application. All he has to avert in the application is that since the stipulated 60 or 90-day period has expired and the charge sheet has not been filed, he is entitled to bail, and such indefeasible right cannot be defeated by filing the charge sheet after the accused has offered to furnish bail. In M. Ravindran, it was cited that whenever there is an ambiguity in the construction of a penal statute, the court must favor the interpretation which protects the rights of the accused. In Rakesh Paul, it was held that where on reading the statute, if two views are possible, then the provision that curtails the individual liberty should be read strictly. Here, since Article 21 is invoked, the court should lean in favor of the interpretation that upholds and protects personal liberty. Now, for example, if an accused is produced before a magistrate, say at 11:50 p.m., it has more to do with the police producing the accused within the prescribed 24-hour period as mandated under Section 57 of CRPC. Therefore, the legal position of Proviso E of Section 167, subsection 2 of CRPC cannot be resolved in favor of the investigation agencies. Because of the legal vacuum in the application of Section 167, the court opted for an interpretation which advances the cause of personal liberty. Therefore, the Supreme Court upheld the order of the High Court granting default bail to the respondents by applying the Proviso A of Section 167, subsection 2 of CRPC. Thank you.
I didn't go through this judgment, but what I could understand from this is that the period of remand must be detective while we calculate the period for statutory bail. As already mentioned by Nivya, I already mentioned in earlier cases also that in Bikramjit Singh versus State of Punjab, the 167 clause 2 forms the important cardinal part of Article 21, which is right to life and personal liberty, and it forms part of the procedure established by law. So, personal liberty is supposed to be one of the cardinal and profound aspect when it comes to handling of persons by a state. So, in this particular case, also a more lenient view has been taken by the court, and I also mentioned most of the points related to 167 close to was mentioned when discussed by us in SFIO versus Rahul Modi, a previous discussion. The YouTube video is available in which almost all the points were mentioned. And in that particular video, I had mentioned about M. Ravindran's case also, wherein uh, what happened was he was presented before the uh, court for mm, taking statutory bail. His application, he moved the application for statutory bail, and police filed charge sheet just during the afternoon. And what the Supreme Court said was that once a right of statutory bail was moved by the appellant or the accused, it is said to be away. And so supplementary charge sheet after filing, after moving of the regular bail application will not be considered. From the plain reading of the same, it is, from the understanding of the same, it is well clear that nowadays court is more of giving more importance to personal liberty of individuals. So this case also fall in that bucket of cases wherein court is considering a lenient, more flexible view. Yes, and one more thing is which I've also mentioned in that Rahul Modi judgment itself, wherein the 268th Law Commission report, which was submitted by the Law Commission dated May 2017, it was mentioned regarding an amendment to 167 clause 2 by giving a provision that if there is any medical issues with relate to the accused person in custody, that period should be deducted when that person moves before the uh, court for taking what do you call for regular bail. That is, if in 60 days, after total 60 days, if he is not available for 10 days, then that day must be rejected, that is detected. So effectively, he is in the custody for 50 days only with the law enforcement agencies. So one that is a welcoming provision in this regard. If that recommendation is accepted, then it will be more beneficial. So yes, that's what I need to add in this regard. Thank you, sir.